Good afternoon, everyone. On behalf of the Johnson-Shoyama Graduate School of Public Policy and the Saskatchewan branch of the Canadian Bar Association, I'm pleased to welcome you all to today's panel discussion on misinformation and trust in public institutions. My name is Justin Longo. I'm an associate professor at JSGS, and it's my honor to be the moderator of this event. At this time, I'd like to acknowledge that while today's event is taking place online, the physical locations of both CBA Saskatchewan and JSGS are located on Treaty 4 and Treaty 6 territories, the original lands of the Cree, Ojibwe, Saulteaux, Dakota, Lakota, and Nakota, and the traditional homeland of the Métis. We acknowledge that this event includes speakers from both Ottawa and Toronto, which are situated on the traditional territories of the Algonquin Anishinaabe Nation and the Mississaugas of the Credit, respectively, along with the Anishinaabe, Chippewa, Haudenosaunee, and Wendat peoples. These lands remain home to many diverse First Nations, Inuit, and Métis communities today. We're glad to welcome those of you joining us today from across Turtle Island and make this acknowledgement as an act of reconciliation and gratitude to those whose territory we reside on or are visiting. I encourage you to take a moment to reflect on the land you reside on and think about the place and the people who have safeguarded it throughout time. If you feel comfortable, you're welcome to share your own land acknowledgement in the chat. And as you do, please think about actions we can all take to identify to actively engage in reconciliation. To keep our event running smoothly, we ask that all attendees stay muted and turn off their cameras during the presentation portion of our event. Feel free to turn your cameras back on for the Q&A portion. The format for today's event is as follows. We'll start with introductory remarks from our panelists and a roundtable discussion that will take us to the top of the hour. Following this, we'll open it up to audience Q&A for the remaining time. If you'd like to ask a question, please use the Zoom chat function to send your question directly to me, and I'll pose your question to the panel or ask you to open up your microphone and ask the question yourself. Feel free to submit questions at any time during today's event. If you have any logistical questions during today's event, please don't hesitate to send a message to Karen Jaster-LaForge via the chat, and you can find Karen's contact information in the chat. Please note that this presentation is being recorded and will be available for viewing on the JSGS website at a later date. This lecture would not exist if not for the partnership between the Johnson-Shoyama Graduate School of Public Policy and the Saskatchewan branch of the Canadian Bar Association. Canadian Bar Association Saskatchewan branch represents over 1,300 legal professionals in Saskatchewan and is part of a national network of 39,000 members across Canada. As a trusted advocate for the legal profession, CBA Saskatchewan is dedicated to advancing justice, improving access to legal resources, and strengthening the rule of law. Through education, advocacy, and a commitment to equity and well-being, they support members in upholding the highest standards of legal excellence. JSGS is a national hub for advanced study and research in public policy and public administration. JSGS is a partnership of the University of Regina and the University of Saskatchewan, based on the spirit of cooperation and collaboration that defines Saskatchewan, and named in honor of two of Saskatchewan's legendary public servants, Al Johnson and Tom Shoyama, each of whom reached the heights of the public service in Canada and whose impact endures to this day. Since its inception in 2007, JSGS has come to be regarded as one of Canada's leading policy schools for educating graduate students and public servants interested in and devoted to advancing public value. As noted, today's event focuses on the timely and pressing issue of misinformation and trust in public institutions. I have to say personally, I'm really relieved that I actually made it here on time today, as I was pulled over by the federal police on the way here for having illegal window tinting, a lift kit installed on my truck, and I was driving, believe it or not, 42 kilometers an hour on the highway that now has a 40 kilometer per hour speed limit. If you don't believe me, have a listen to this.
Effective June the 1st. All vehicles manufactured before 2000 will be gradually phased off. Canadian roads, due to safety and emission standards, non-compliant window tints, including rear windows, are now prohibited. Drivers will have a 14-day grace period to install approved replacements. Lifts and or levels on trucks must be taken off. For not only the owner's safety, but for the people around, it doesn't make sense to have a truck jacked in the air. These will be taken very seriously.
Now, we are clearly living in a different world of the days of Walter Cronkite and Knowlton Nash. The rise of social media and now the ability of anyone with an internet connection to make a video deepfake like that one that can increasingly fool even the more skeptical viewer. Misinformation now has a platform. And that misinformation is undermining public trust in our institutions, including our electoral and legal systems. Thankfully, we have three esteemed panelists to help us start to make sense of this new world, its implications for our governance and society, and what we might do about it. I won't read their full biographies in full, which, given the depth and range of their experience and expertise, would take up most of the time we have together today. Instead, I'll briefly introduce each of them to you and ask Karen to kindly paste into the chat more detail about each of our speakers. Let me begin by introducing Lynne Vicars, who is the current president of the Canadian Bar Association. Lynne serves as a deputy judge of the Ontario Superior Court of Justice, Small Claims Court Division in Toronto. As president of the Ontario Bar Association in 2018-2019, Lynne led initiatives promoting gender equality, digital transformation, and modernization in the legal profession, priorities which she continues to advance today. Next, I'd like to welcome Anastasia-Maria Hountalas, a partner at Steinecke, Maciura, LeBlanc in Toronto, where she advises and represents clients in all aspects of professional regulation. Amongst her many responsibilities, Anastasia-Maria is an adjunct professor in the University of Toronto Faculty of Law's Global Professional Masters of Law program, where she teaches professional responsibility, and has also served in several volunteer capacities with the Toronto-based not-for-profit organization Young Women in Law, which supports women lawyers in their early stages of practice. And finally, we're also joined by Michael Powell, a full professor at the University of Ottawa Faculty of Law, where he researches the law of democracy, comparative constitutional law, and election law. Amongst his many publications, Michael was the co-editor of Cyber Threats to Canadian Democracy, published by McGill Queen's University Press in 2022, which is the first book on election cybersecurity in Canada and which was named one of the Hill Times Political Books of the Year. Lynne, Anastasia-Maria, and Michael, it's my pleasure to welcome you all three of you, to this platform. I'd like to start by asking each of you in turn to take a few minutes to describe what you see as the challenge or situation facing us today and how it relates to your current work. Misinformation and the effect it's having on our public institutions is clearly a critical issue. We saw that just last week in a report on a post-election poll by Leger that indicated that 3/4 of Canadians believe misinformation had an impact on the recent federal election, reflecting growing worries about foreign interference and online disinformation campaigns. So clearly, the issue is of current interest, not just to governments and experts such as yourselves, but to the public more broadly. So Lynne Vicars, could I start by asking you for your perspective as president of the Canadian Bar Association, for your view on the importance of understanding and dealing with this rising tide of misinformation?
Thank you, Justin, and hello, everyone. It's an absolute pleasure to join you virtually today. As president of the Canadian Bar Association, I have made it my highest priority this year to champion and protect trust in our justice system and the institutions that support it. Today, I'm honored to join this important panel to discuss misinformation and its truly profound effects on public trust in these institutions, especially in our courts and legal institutions. In recent months, I've spoken with members of the legal community across the country, and our conversations have been only reinforcing a simple truth. For justice to thrive, our courts must function free from undue influence, intimidation, or public suspicion fueled by misinformation. It's really no exaggeration to say that we find ourselves at a crossroads. For so long, our justice system has been so strong and central to our democracy that we've really had the luxury of taking it for granted. We haven't had to explain why our justice system is foundational because people took it on faith that it was. Everyone accepted that our democracy does not work without the rule of law, without an independent judiciary, without solicitor-client privilege, and without access to justice for all. But times have changed. Polarization, cynicism, and misinformation are now striking at the very bedrock of our society, such that we can't take our justice system for granted anymore. These forces are not only distorting the public's understanding of how the legal system works and how judicial decisions are made, they're also fueling a broader erosion of trust in the concept of judicial independence. Too often, judicial independence is mischaracterized or misunderstood, and sometimes we've seen deliberately so. And most troubling of all is these misunderstandings, they aren't just coming from the fringes anymore. Judicial independence has been threatened not only by commentators or individuals online, but as we have all watched in horror in the US, by those in the very highest positions of power. So we have to recognize this for what it is. It's a direct threat to the rule of law. When judges are subjected to personal attacks, when courts are pressured by political or public opinion, when lawyers are intimidated simply for representing unpopular clients, we're not just undermining individual cases, we're eroding the very framework that protects all of our rights and freedoms. So respect for legal institutions is really not optional. It's essential. And without it, justice can't function. Without it, democracy itself falters. And that's why our association stands firmly in defense of judicial independence and the rule of law. Judges must be free to decide cases based solely on the law and the evidence before them, without fear or favor. And lawyers must be free to advocate for their clients and for the integrity of the legal process without the fear of reprisal. I also believe that we all have a duty as legal professionals and as citizens to lead by example. We must speak out against misinformation when we see it. We must educate the public about the critical role of an independent judiciary, and we must work collaboratively with our partners in the justice system to strengthen the transparency, efficiency, and accessibility of our courts. I'm really proud of some of the steps that the CBA has taken. We've released just recently a messaging guide, which will not only help us better align our own messaging across our association, but will also help our members engage and educate the public on these principles through speakers, forums, and other outreach to the public. In collaboration with the Law Commission of Canada, we've also launched a journalism fellowship to support in-depth journalistic exploration of critical and emerging law and justice issues in Canada. We need great journalism so that journalists can help us educate the public and remove some of the threats of misinformation. And we continue to work with our branches and our colleagues across the justice sector to address backlogs, modernize systems, and uphold the principles that underpin our justice system to keep our justice system strong. We see that this is the time to lead by example. Together, we can show the legal community is not just a defender of justice, but also a source of innovation and a force for progress. Through some of our initiatives, we can engage with the public to heighten the awareness about the importance of the rule of law and restore trust in the institutions that underpin our democracy. But these challenges before us demand a united and proactive legal profession. And I truly believe that the CBA is the organization that makes this type of unity not only possible, but profoundly impactful.
Excellent. Thank you, Lynne. Anastasia-Maria Hountalas, as a practicing lawyer and your particular focus on professional regulation and responsibility, How would you characterize your interest and concerns with misinformation and the effect it might have on our institutions?
Yeah, so I work in professional regulation, as you said. All of my clients are professional regulators, so they regulate various professions and industries in Ontario and across Canada more broadly. And one of the roles that regulators play is ensuring that their practitioners, so the professionals that we all engage with in our day-to-day lives, behave and communicate in both a professional manner and in a way that is consistent with the standards of practice of that profession, whatever it may be, whether it's a health profession or a particular consumer-based industry, whatever the case may be. Now, so there are a few ways that regulators are grappling with misinformation. And one scenario where we see that this comes up quite a lot is where regulated professionals purport to provide advice or give information on subjects that are beyond their scope of practice. So, for example, we saw this coming up quite a lot in relation to the COVID-19 pandemic. We had instances where, for instance, health professionals who were not authorized to treat COVID-19 were providing misleading or false information about the pandemic or about perhaps prevention and treatment of COVID. And then there was a related scenario where regulated professionals, the professional in question is authorized and is properly qualified to provide advice or opinions on a particular topic, but they're doing so in a manner that's either inconsistent with sort of widely accepted standards or science, and is raising concerns that they're not maintaining the standards of practice of their profession. So continuing in the example of COVID, we see a number of cases coming up involving physicians in Canada, but also in other jurisdictions in the UK, where they're promoting or sharing misinformation about the prevention and treatment of COVID in their role as a physician. There was actually quite an interesting case that came out of the pandemic, but was heard, I believe it was last year in the UK. And it was a physician who had found himself in hot water with his regulator in respect of a series of YouTube videos that he made where he shared, I think what is generally acknowledged to be misinformation, including that COVID doesn't exist, that it's a conspiracy, or that vaccines, misinformation about vaccines, including that they contained microchips. And the court in that one actually went up quite a few levels of appeal, and was really interesting because I think they took a pretty reasonable approach, which was that they divided the comments made by this physician into those that were essentially sufficiently reasonable to amount to a legitimate differing medical opinion. So it may not be mainstream, but it's supportable. And then those that weren't and really amounted to misinformation. And it focused on the latter category. And then, of course, there's also another sort of related area in the world of professional regulation, which involves concerns about comments made by professionals, often on social media, that are considered to be unprofessional or derogatory towards a particular group of people or perhaps an institution. And this really gives rise to the question of, whether the post actually or the speech actually contains misinformation or if it's just rude. And both may be may warrant some regulatory action, but they're sort of different considerations, although related. And so, what all of this has in common is it engages really this interplay between the right to free expression in the Canadian context and the obligation of the regulator, which is really there only to protect the public. And where the law in Ontario for now has landed is really that there's no doubt that these types of comments and speeches made by professionals are covered by Section 2B of the Charter, their expression, but that right's not absolute, as we all know. And in particular, in the context of regulation, there's been quite a lot of litigation, some of which I'm sure you're all thinking about, that was highly covered in the media, about things that professionals have said, regulated professionals have said. And it's generally been, at least in Ontario, interpreted that professional regulators are entitled to limit their members' expression, provided that the limitation is reasonable, proportionate, and consistent with the regulator's role of protecting the public. And so the question, I thought one court said it nicely, the question isn't whether a member can express themselves, because of course they can. It's just that when you take on additional regulatory obligations by joining a regulated profession, there may be consequences to that type of expression, depending on the context that you make it in. So I think that's really where this whole idea of misinformation and protected speech comes into play in the context of professional regulation.
Excellent. Thank you, Anastasia-Maria. And we're going to come back to and disentangle some of those issues in the later part of the conversation, and hopefully get a chance to tie it to the Saskatchewan context also. But first, Michael Powell. Michael, as I noted in the introduction, the issue of misinformation and democracy, particularly in our elections, is of critical importance. So what are the particular challenges facing our institutions that you see being posed by misinformation?
Thanks very much, Justin, and it's a real pleasure to be here with all of you and my co-panelists, and I'm looking forward to the discussion. So I study democracy. I'm an election lawyer and constitutional lawyer by training. Wasn't the case maybe when I started out, but today you can't really get the full picture about what's going on with democracy unless you're taking a look at misinformation and disinformation as well. So it really is one of the defining issues. And so a few things that I might want to just say up front to kind of set the table for the discussion for the audience here. One is it's not a Canadian only problem. You cited that poll, Justin, and everyone will have their own experience in the media they consumed in the federal election, but there was lots of mis and disinformation out there. And so one of the important things I think to keep in mind is it is a global problem. It is a structural problem related to the growth of social media platforms, because a lot of mis and disinformation happens online. People will have seen the rallies and the door knocking that political parties and candidates and leaders engaged in during the election, but a lot of politics is also happening online. And so that along with shifts in the information environment, have made mis and disinformation just much more a feature of contemporary democratic politics than it was before. So we've always had problems with disinformation. Something worth saying as well, Canada Elections Act and some of the provincial statutes had provisions saying it's illegal to lie that a candidate has died in the middle of an election campaign. Kind of a peculiar thing. Why is that there? It's because that was a very efficient tool of disinformation back in the day before TV and the internet, where information could spread very easily. So disinformation's always been a problem. What's changed is the ease at which purveyors of disinformation can spread the disinformation. The cost has lowered dramatically. It doesn't cost anything really to spread information online, and the potential audience is massive compared to spreading a lie about whether a candidate is alive or deceased in a riding kind of ear to ear. So the scope of how disinformation operates has really changed. Another important point to get out there is there are very different goals behind disinformation. Sometimes it could be as narrow as trying to change an individual's vote in a particular riding, in a particular election. You can imagine the kind of disinformation saying, this candidate has done something horrible, don't vote for them, or vote in the wrong day or in the wrong polling station, something like that, which we do sometimes see in Canada. The goals can be much broader, however. Autocratic governments who are interested in interfering in Canadian elections generally have the goal of undermining democracy itself. And so we have to kind of assess how disinformation is working its way through the system based on who is spreading it, what their goals are, what tactics they're using. Kind of third point to say up front is we're in the early stages of policy reforms to try to deal with disinformation in the electoral space. One of the things that constrains what we can do, and maybe constrains is the wrong word, but constrains what we can do, is the Charter of Rights. Freedom of political expression is at the core of the protection for expression in the Charter, as it should be. Politics is a bit rough and tumble, always has been, probably always will be, and we don't want a state agency declaring what is true or false and therefore what can be said during an election campaign. So we value political expression, and we should. That does mean it restricts to some degree the options that we have for dealing with disinformation. So federally, Canada Elections Act, the kind of first steps that have been taken include having a repository of ads that are spread on social media platforms so we can see what is being said, let the sun shine in, and we can assess its veracity or whether it's a lie. Prohibitions on impersonating candidates and leaders or the chief electoral officer, which is very easy to do now with artificial intelligence and various new technologies. So we've taken some steps forward. Those are really first or tentative steps because the technology is always changing. The platforms that are being used are changing. My students talk about seeing disinformation on dating platforms now. That wasn't the case a couple of election cycles ago. Video game platforms are now a relevant platform as well. So disinformation is an ongoing feature of Canadian politics. That's not going to change. And any policy solutions we come up with are going to have to be quite nimble to adapt to new technologies and new platforms within the constraints that the Charter of Rights sets for us. So I'll leave it there.
All right, perfect. Thank you, Michael, and thank you all. Michael, if I can stay on this issue of some of your comments. So the deep fake that we showed at the beginning of today's panel, that clearly illegal under the Elections Canada Act to impersonate what the Prime Minister said?
If it happened during the election campaign, then yes. And there's some movement to have amendments to expand the time period in which the offenses happen. There's a lot of offenses in the election statutes that are really just tied around the election, because that's when the kind of regulatory hammer is supposed to fall. But as we see, politics is now in permanent campaign mode, 365 days a year, 24/7. And so we might need to expand the time period in which the prohibitions operate.
Okay, interesting. Also on the issue of the election, and the election itself as an operation. So I'm looking at this as a non-expert, and I look at it, it looks pretty robust to me. I mean, we have paper ballots, most people going to a polling place, marking a paper ballot, and we don't seem to have a lot of controversy for disputing who won individual ridings and the overall election. Am I being naive, or is there something more about the operation of elections we need to be careful about?
Yeah, overall, we're in a good position, but we're still vulnerable. And I find myself often in the position of trying to counsel against complacency because of these broader trends that are going on in democracy globally. So if I can put some numbers on it, I'm on the advisory board of a group called the Electoral Integrity Project. One of the things that the project does is it runs a study where experts around the world are asked their perception of how free and fair an election is in countries all around the world. And so it's not a perfect measure. It's asking experts, but it's one of the pretty good ones that we have. And that measure says Canada has the fourth best elections in the world after Austria, Sweden, and Denmark. So that data doesn't include the most recent federal election or the more recent provincial elections or anything like that. So we have to have that caveat in mind. But overall, we are in a good position. With that being said, there are some longstanding issues in this federal election campaign. There were concerns about access to the ballot box by First Nations voters and voters in some remote communities. I don't have any more information than what's in the media reports, but that's a long-standing issue across jurisdictions in Canada that we still have lots more work to do on. Money in politics is an ongoing issue. There are few restrictions in between election campaigns, despite the fact that we have permanent campaigning going on, including by interest groups of all kinds. So large amounts of money can and be spent and is often spent that might have a disproportionate influence on elections. We had a commission of inquiry into foreign interference recently. That is an issue we have to take very seriously, and hope we will continue to do going forward. The thing with disinformation that I think gets at your question is it's a tactic used by parties and interest groups and candidates and leaders and foreign governments, but the target is increasingly kind of our apparatus of election administration. So in the US, they talked about the big lie, claiming the presidential election was stolen. There is no evidence academically in newspaper reports or in the many court cases that the big lie is true. That's why we call it the big lie. But it's a tactic used to undermine faith and the confidence in the electoral apparatus and the voting system. And voters who used to believe mail-in voting was safe and fair overwhelmingly don't when primed by political leaders to change their views. So we have seen a little bit of that in Canada, more at the provincial level, I think, than at the federal level. But we are certainly vulnerable to disinformation, specifically about the electoral system and the electoral process.
Yeah, on that question of apparatus, just to pick up on that. So in Saskatchewan, we have the government, at least a legislative committee, explicitly rejecting the notion of optical ballot readers, whereas in British Columbia, in my experience, or at least my knowledge, have adopted them. So is this part of the worry around misinformation, that there's the ability to generate concern that there might be something that's missed in using something like an optical character reader to count a ballot?
Yeah, I can't say specifically as to the motivations of the legislature or the committee. Generally, there is a lot of skepticism about technology in the election process of election administration. And I think what some of the discussion in the US around mail-in balloting and other procedures shows us is anything can be the target of disinformation if people are inclined to believe it. And with polarization and some other broader factors, we are at risk of similar things happening. Could be optical scanners, could be ballot tabulators, could be network polling stations. There's a whole host of things that election administrators use that could potentially be criticized through disinformation or misinformation.
I'd like to talk a bit about the platforms, the social media platforms, and also invite the other panelists, Anastasia-Maria or Lynne, to chime in if you have any thoughts. But Michael, if I can start with the Online News Act, Bill C-18, that required platforms like Facebook to pay Canadian news organizations if someone shared their content on the platform. So in response, Facebook, Meta, blocked all news links from Canadian media on those sites. So this has led to a sharp drop in views of Canadian news, what we might call, if I can say, legitimate news on these platforms, and has left Canadians who use those platforms exposed to potentially more misinformation and AI-generated fake news. Did Bill C-18 have this unintended consequence, and is there a way back from it?
That's a big question on the way back. I would say Bill C-18, along with some of the changes to the Elections Act that applied to social media platforms, some of the platforms decided what they should do is comply. Others decided what they should do is withdraw from the marketplace entirely. Some of the platforms, for example, don't run political ads at all because they don't want to be subject to the regulatory regime. So the News Act and the Elections Act amendments, I think, signal to us more robust regulation of social media platforms is necessary. And that sometimes means the Canadian government has to be in conflict with the platforms. That's awkward for them for a number of different reasons, but I think is a more robust regulatory regime is necessary.
All right. Thank you. Thank you, Michael. Anastasia-Maria, I'd like to move to the issue of misinformation cases involving professionals that you spoke about in your comments earlier, something you obviously have a lot of experience with and have written about recently. Karen's going to paste a link in the chat about a particular article on misinformation as the basis for limiting charter rights. So in that article, you describe how courts are trying to balance charter rights and professional misconduct And you talk about a recent decision that seems to let regulators act against misinformation that might harm the public. Again, you spoke a bit about this in your introduction, but curious how you see this evolving framework affecting future professional misconduct cases, particularly in this digital age where professionals can reach big audiences with social media.
Yeah, I think it's tricky for regulators, and in fairness, it's probably tricky for professionals too, to make sure that you're complying and keeping up with the most up-to-date social media as it changes so quickly, as we've heard a lot about today. When it comes to balancing charter, regulators have to balance the charter, a professional's charter rights, including the right to free expression, which is the one that comes up the most when we talk about posting on social media or making comments, with the statutory obligations, or the statutory objectives rather, of the regulator. So what that means is that the regulators are generally there to protect the public. It's usually their principal, if not only, object. And at the same time, we have the right to free expression, and we want to have constructive debate and a lively discussion around by professionals about their professions. And so we have a structure that's set out by the Supreme Court of Canada in the Doré case, which was actually about lawyers in Quebec, and lawyers and judges. So I'm sure most of you are familiar with it. But what it says basically in the context of regulators is that when a regulator's activities, regardless of what those activities might be, impact their members, so a professional's charter rights, they have to ask themselves how best to protect the charter right while still carrying out their public protection mandate or objective. So it's a balancing exercise. And certainly when it comes to misinformation in cases involving or actions by the regulator targeted at misinformation, I think it's pretty accepted, or I hope it's pretty accepted, that this can be dangerous or harmful to the public in a variety of different ways. And this is especially the case, I think, when it's being spread by someone who is part of a profession that holds a position of public trust. And we want regulated professions and to have the buy-in of the public. We want the public to have confidence in the profession's ability to regulate itself, if it's a self-regulated profession, or to be regulated safely. I think it's perhaps even more apt when we have a professional who is spreading misinformation and relying on their credentials to get credibility in those comments. So it really, I think, has certain elements by being in a regulated profession that heighten perhaps the potential impact on the public. Mm-hmm. But on the flip side, we also want to be able to ensure that regulated professionals engage in lively discourse and are able to engage in debate, critique, questioning, to ensure that that is protected as well. And so it's really a balancing, it's literally a legal balancing act, but also a balancing act in terms of when to step in and when regulators should intervene to be able to step in appropriately when that discourse contains misinformation, especially in areas, we see this a lot in terms of public health and health concerns, but also be able to maintain that discourse. So, this is the balancing act, both legally and figuratively, for regulators when they're engaging in activities that might impact a charter right.
Yeah, and I think you're pointing towards at least that tension, that balancing act is, I think, well illustrated here in Saskatchewan. There's an interesting and complex case. You're likely aware of. Carolyn Strom was a registered nurse who posted on Facebook criticizing the care that her grandfather received at a long-term care facility. She was charged with professional misconduct, fined $26,000, and this was finally overturned by the Saskatchewan Court of Appeal, which found that the regulatory body, their actions were unjustifiable and it infringed upon Ms. Strom's charter right to freedom of expression. So help me make sense of that difference here. Is it between the opinion and misinformation? How do we distinguish between opinion and misinformation? Is it that Ms. Strom was identified as a nurse or was speaking personally as the granddaughter of this patient? And is this wrapped up in the broader new thinking we have to engage in around social media as a different platform that people can now speak to.
So, I mean, I think there are a few discipline cases probably in Canada that have gotten more discussion and sort of media coverage than that one. And it was very widely covered. It was quite widely critiqued. She was found to have engaged in professional misconduct. I think actually in terms of the amount of money that she was required to pay, if I'm not mistaken, I think it was a $1,000 fine and the rest was actually costs.
Okay.
So it sounds, it sounds like a very high amount when you're reading it, but I think that part of it was legal costs. But certainly this engages, what regulators often refer to as off-duty conduct. So things that aren't taking place in the practice of your profession, but that are happening when you're off duty, that whether or not you agree with the regulator's position in that particular case, but that impact their professionalism or impact their work in some way or related to. And it is very well established in Canada that regulators have an ability to intervene in certain types of off-duty conduct. We see this in cases that involve professionalism, sometimes in other cases, not the Strom case, but in cases where a regulated professional has been found guilty, for instance, of a very serious crime that didn't occur in the practice of the profession, but may be relevant to their ability to continue to practice safely. So we see off-duty conduct coming in a number of a number of scenarios, separate and apart from the social media context, although that is the one that's probably top of mind in the media.
Mm-hmm. And is it? Sorry, go ahead.
Sorry, no, go ahead.
Well, I'm just wondering if social media has changed the thinking around this. So and I'm sorry I don't know the details, but previously there was a nurse in Saskatchewan who was disciplined for engaging in a physical protest, an actual protest held outside the legislature in support of an anti-abortion protest, and was found by the courts to have been unreasonably constrained because that was their right to free speech. This one seemed to drag on longer. And was it because it was social media that was different, or is it? Is social media and to the extent of things like deepfakes making this more complex?
Yeah, I mean, certainly the advent of AI and deepfakes is making, I think, everything more complex. It's very difficult on first blush to see if something is true or not, or is real or not. And that's not something that I think is unique to regulated professionals, but is certainly something we're all engaging with. I think from the regulatory perspective, the regulator's perspective, there's sort of two facets for them to consider. And the first is this misinformation, which is not always so easy to tell. I think as Mike was talking about, it's not always obvious at first blush. And whether or not something is false or misleading is a separate question sometimes from whether it may or may not be. It could be real and still inappropriate or unprofessional to be talking about in the context of one's profession. And then, this of course goes back to the idea of regulated professionals taking on, when they join a profession, certain additional professional and ethical obligations, and the regulator being able to require them to meet those standards. So I think, the underlying mechanisms or tools have always existed, but in terms of social media, in terms of deepfakes, it makes it just a lot more difficult to make sure that you're being accurate and that the information that you're engaging with online is real or not. So I think that's a struggle for everyone, but in particular for professionals who are, who are using social media and are choosing to engage with this types of content.
Right, good. Thanks, Anastasia-Maria. Lynne Vicars, I wonder if I can move to the issue of increasing attacks on judicial independence, something you spoke about in your introductory comments. And this isn't
Just before we go there, I wanted to pick up on just something Anastasia said, because I don't know whether people have seen a recent case came out just this week in Ontario, and I'm going to talk about AI just for a second and the risks of misinformation, but from a regulatory perspective, in the case of Co v. Lee, 2025, I think that was heard on May 1st, just came out this week. Justice Myers found that the applicant's factum may have been created by AI, with cases either being hallucinated or not supporting the propositions of law, which the lawyer submitted to the court, both in writing in the factum and then again orally during submissions. And Justice Myers went on to cite the duty that lawyers have to the court to faithfully represent the law, not to fabricate case precedents, and to use technology competently, and said it is the litigation lawyer's most fundamental duty not to mislead the court. And that lawyer has now been ordered to show cause why she should not be cited for contempt. So there we have just this week sort of the intersection of misinformation and the regulatory, the duties of lawyers, legal professional responsibility of lawyers right on display here in Ontario. So I just wanted to add that.
Very interesting. And I did see also in a different context, a victim impact statement from a deceased person, the victim of the crime in which the person was being sentenced, was allowed by that court. And I'm sorry that I don't have the details in front of me. An AI-generated victim impact statement written by the family and using the likeness of the deceased person to deliver the victim impact statement to the court. So we're in definitely a brave new world, aren't we, on different fronts?
But you know what's key to me here? The risk is not the technology. It's the risk of the people that are using the technology. And here we're talking about lawyers. Lawyers have to use the technology properly. And just as we all wouldn't just take our articling student or our student's factum and present that to the court, we need to check. We need to check the sources. And so it's really not it's not new principles. It's just learning to use the tool effectively. Because I'm always afraid when people read these type of cases, they're going to say, we can't use AI, we've got to pull back. No, it's here. We're going to have to use AI, but we just have to do it effectively. So one of the things we're doing at the CBA, we've addressed this. This is on our radar. And we're hoping to be able to announce soon that we're going to have some tools to help train lawyers on the effective use of AI in their legal practice. So I'll go back to your question on judicial independence, but I just wanted to add that.
Well, that's a really interesting and important segue. And Karen has worked her magic in the chat to find both the case, Lynne, that you were referring to, and the one, turns out it was in Arizona, the one I was referring to on the victim impact statement. So, but yeah, let's go back to this issue of, as you were saying in your introductory comments, about attacks on judicial independence and happening not just through social media misinformation. So, if you can speak a bit more about that, how misinformation campaigns are undermining public support for the judicial system in Canada, and what role should the legal associations and legal profession play in countering misconceptions about our judicial system?
Well, many people only encounter the justice system during moments of true personal crisis in their lives. So during family breakdowns or a criminal charge or a landlord dispute. And when they do, they often feel intimidated, alienated, and confused. And at those times, they're even more vulnerable to misinformation. For those who've never come into contact with it, the justice system can seem remote and disconnected from their everyday lives. And that's why I say this is a vulnerable a time when misinformation can really impact them. So when a political leader calls judicial independence a joke, that poses a real risk to the public's perception of whether they're going to be treated fairly by the system. When public officials spread misinformation suggesting that judges are biased to a particular ideology or should be biased to a particular ideology, or that they should decide cases on any other basis other than the facts and the application of the law to those facts, that's when we have a real problem. Because if the public loses trust in the justice system, litigants might seek other avenues to settle their disputes. And then that's going to undermine the entire foundation of our democratic society. So it's how do we deal with it? I have been speaking out across the country in support of judicial independence. But the issue is, we lawyers all know what that means. The public doesn't necessarily. So it's not just being vigilant and speaking out. It's us lawyers all amplifying the story and explaining to the public why judicial independence is is so important to our democracy, and putting it in terms that the public can understand. So I go back to the toolkit that the CBA's developed. That's one way lawyers can help communicate with their families or their clients, or if they're speaking at forums, to get this across to the public of why this is so important to them. And it's a bit like, as Michael said, the ease with which misinformation spreads is so rapid and doesn't have cost bounds, that you can do this almost for free now. So it's a bit like paying whack-a-mole, but we have to be vigilant. We have to call it out when we see it. And it's very helpful if we can all amplify each other's voices when we do speak out.
This growing online discourse around comparing our appointed judiciary to the predominantly elected judicial system in the United States suggests it's built on a suggestion that appointed judges somehow lack democratic legitimacy. I'll get Karen to put into the chat a recent article that quotes Premier Ford of Ontario talking about bleeding heart judges and those who are overruling the government. We don't have to look very far to see other premiers who have made similar comments. This isn't quite is this misinformation, or is this?
Well, I think it's on the fringe of misinformation. I do think it is. But when you compare Canadian judges who have been appointed from a process where applications are vetted by nonpartisan judicial advisory committees, when you compare those to U.S. models, including, clear partisan appointments south of the border and elected judges, it oversimplifies the issue, and it really misrepresents how democratic, what the democratic legitimacy is, how it's maintained here in Canada. Our system is merit-based, it's rigorous, and it's largely insulated from political influence. Not completely, but again, it's when we see attacks, and I won't name any particular province, but when we see a particular province trying to make changes that affect or politicalize the existing system, we speak out, and we have to continue to do that. An impartial, apolitical court is fundamental to both the rule of law and public trust in our institutions. And this sort of false narrative that elected judges could possibly be better than the appointment process that we have in Canada centers on a complete misunderstanding of how that works. If you have judges who are elected, there's potential for political influence on their decision making. That undermines their judicial independence, and elections can lead to candidates who have to pander to popular opinion. We don't want that in Canada. We see what the results of that are south of the border. We don't want an individual or a corporation being able to invest in the election of a judge. And so again, we have to be vigilant to protect the system that we have in Canada, which I think is a very good one. Is it perfect? No, it's not perfect, but I think it's far better, certainly far better than our neighbors to the south.
Yeah, if I could, maybe Premier Ford will want to consider what would happen if a judge does have democratic legitimacy by being elected and is now in a position of that authority, as well as having what he's referring to as democratic legitimacy. Lastly, on this point, Lynne, if I could ask about the open court principle that we have in our proceedings and decisions being largely public as being fundamental to our democracy. We saw with the deep fake generated around the Prime Minister speaking about one issue, but being represented to speak about a different issue. Do you worry about misrepresentation either through deep fakes or social media of court proceedings? And how does the media and legal educators, what role can they play in countering those that direction?
Yeah, again, Canada's open court principle is truly another cornerstone of our democracy, because it ensures that proceedings and decisions are accessible to the public. But it is true that the same transparency can be exploited, particularly in today's fragmented, fast-moving media environment. When judicial decisions are selectively quoted or, stripped of content and circulated with misleading commentary, they can be weaponized and used to erode the trust in the judiciary, certainly. So again, I'll point to, and I can't remember if I mentioned this in my opening comments. I think I did a little bit, but we've partnered with the Law Commission of Canada for a journalism fellowship to provide journalists with the ability to do some really in-depth journalism and have access to lawyers that are going to help provide the truth, help to suss out some of the misinformation. So that's one small step we've taken. But we're also doing some targeted programming for journalists to help journalists to truly understand the law and how legal decisions are written, to try again to build an army of people that can help combat the public being misinformed about judicial decisions or any other aspect of how our judicial system functions.
Excellent. Thanks, Lynne. I'm going to move on to some questions that have been accumulating from our audience, but I do want to follow on this conversation we've been having, Lynne, generally about the use of AI in courts. You cited the recent court case in Ontario where a lawyer was chastised for using it. But one of the dilemmas we're facing, for example, in this policy school where I teach students who are looking to develop their skills to become public servants, is what is the legitimate use of artificial intelligence in their work, both on the generative artificial intelligence side of essentially using the tool to write material, or to use generative AI to, for example, summarize material. Is there a place in the legal profession, or in the judiciary for that matter, for using the assistance of those tools to help make sense either of large volumes of information, to summarize it, or to take, let me say bullet points and develop that into a more comprehensive statement?
So I definitely think there's room for that, but I think what there has to be transparency. You have to say how you've used it, what prompts you used, what large data set you pointed the tool at. All of that has to be completely transparent. So I'm a huge advocate for the use of AI, but it has to be used responsibly, and there has to be complete transparency so that bias and hallucinations and anything, all of the other risks of AI can be mitigated as much as possible.
That's excellent. That resonates with the approach that we, at least myself, I'm taking here in working with our students. It is about that transparency, as well as a critical reflection on what material is coming out of the generative AI, not just to say, it told me this, so it must be true.
Exactly. You have to constantly test you have to test the bot. You have to test the tool. Cite your sources. Why do you believe that? Point them to another source. Professor Longo said this in his paper on that. Consider that, and it's all about how prompting the tool, but also the transparency in explaining. We're not using it in courts yet, and I think it will be some time, but I believe that we will all get there eventually. But it's going to be the transparency that's key.
I always say if someone cites Professor Longo in something he said, it's immediately suspect, so we should discount it. I'll ask Anastasia-Maria or Michael if you have any thoughts on this question about legitimate uses of artificial intelligence in legal proceedings or legal analysis. Anastasia-Maria?
Yeah, I mean, I think I agree with what Lynn is saying. We want to use tools that can help us be more efficient and more effective in the things that we're doing. It's just that you have to be able to, much like you wouldn't take summaries of case law that someone else prepared and just use them. You should be using them as a tool, not just as a final product. You have to be able to review them and stand by your sources. But as a starting point to help, of course. I mean, I think, why wouldn't we make use of a tool as long as we're using it properly and responsibly?
All right, thank you. Michael, I'm not sure if you have any thoughts on that, or if I can jump to another question. You did mention the regulations within the Elections Act around misinterpretation of a person, and that you said the deepfake I showed earlier in an election period would be clearly against the principles or specifics of the Elections Act. Should the government, I think you were implying this, but the government should regulate online platforms more. Should they move to the point of asking platforms or requiring platforms to detect and remove misleading information?
Yeah, that's a great question. So the common link across a bunch disinformation in a bunch of different areas is the social media platforms. It's very hard to craft an effective legal regime that's trying to target individual people who are doing wrongdoing of some kind, right? So um, putting affirmative obligations on the platforms, I think, is the most direct route to getting a better outcome. One example is from the Elections Modernization Act in 2018. The platforms are forbidden from accepting money from a foreign entity to place a political ad. So the obligation is on them. If you want an Airbnb account, you have to show ID and scan it. It wasn't the case in 2018 if you wanted to run a political ad on a bunch of the social media platforms. They did very little verification. It depended on the platform, but there was very little of that going on. Now there's more, partly because of those legal obligations. So imposing more requirements on the platforms, it does cost them something at the end of the day, which is partly why they tend to oppose those measures, but that's often the most direct way to getting a beneficial public policy outcome.
Okay. I'm going to move on to a different question here from the audience, from Robin Mowat. What can institutions do to build public trust proactively rather than reacting to misinformation or controversial statements from public figures? Lynne Vicars has spoken to this, I think, already, but either Michael or Anastasia-Maria, any thoughts on what public institutions can do to react to misinformation from public figures?
I'm happy to start and I'll turn it over to Michael. In terms of it, with respect to regulators, something we see a lot of now that I think is a really good step is education for members and being the regulated professionals about what to look out for. And in particular, we see a lot of social media guides, things like, here's how you can interact with social media, here are the expectations, here's a reminder of how they tie into your professional responsibilities, and really helping to help members engage responsibly and ethically and professionally with social media. Because, I think a lot of us take for granted the ability to engage with social media, and it's not necessarily a skill that everyone is familiar with. And so giving those resources to help people stay on side their professional responsibilities is a really great way to sort of proactively build public confidence and also help people stay out of trouble.
Good, thank you. Michael?
Yeah, proactive is, I think, the appropriate word here. I think lots of public institutions would prefer to have more small c conservative communications strategies. That's very difficult to sustain in this kind of environment. They have to be proactive in putting forth accurate information that people can then rely upon. That means having valuing transparency, and it means acting very quickly, which is sometimes a difficult thing to do. The chief electoral officers across Canada have generally tried to be more transparent, for example, and be more reactive than they used to be in the middle, or more proactive in disclosing information than they used to be about how the electoral process works, knowing it's inevitable there will be some disinformation during an election campaign. So there's kind of a broader lesson there for public bodies around transparency and being proactive.
All right, thank you. I have another question here from Taylor Bendig. I'd like to ask a question about how mis and disinformation differs at the level of local elections, getting away from provincial or federal ones. Do we see anything different happening at local levels? Michael?
There is misinformation and disinformation at the local level. We tend to have less visibility about what is happening because there's less media scrutiny. There are not as many academics paying attention to municipal elections, less of an information infrastructure paying attention to municipal politics. So it happens. We know less about it. And it varies, of course, a lot, right? A municipal election in Edmonton has different issues than a municipal election in Moncton. There aren't political parties. So often in municipal elections across the country. So the issues vary and how the disinformation happens varies, but it is absolutely a facet of municipal politics. Lack of news coverage, to go back to one of your earlier questions, I think is part of that as well. There are fewer reliable, trusted sources of news around municipal politics in many areas of the country, unfortunately.
I've got another question here from, I'm sorry, I don't have a name for this person, but how to hold elected political figures accountable for their misinformation. So examples are judicial appointments we've talked about already, at the federal level, pollution pricing, clean electricity regulations, examples like the Alberta Sovereignty Act and the Saskatchewan First Act. So right now, politicians seem to have absolute freedom of speech, and this is being misused to the detriment of the rule of law and our democracy. Any thoughts or solutions to this problem?
Anyone else? You want me to go on that one? So it goes back to the point about the charter and kind of the nature of politics from the beginning. We want there to be a robust back and forth on public policy issues. That's one of the great features of democracy. Where we've tried to kind of shave off the sharp edges is around very specific types of disinformation that are related to the electoral process itself. So purporting to say something from the chief electoral officer of a jurisdiction is generally illegal in many jurisdictions in Canada. Lying about a candidate or party leader's employment history or citizenship or criminal record, for example, is illegal federally. So that's a type of disinformation that is prohibited. Can kind of think of that as the anti-birther provision, although it predates that debate. It's controversial, but that's one attempt to try to prevent disinformation of a very particular kind about other candidates. But it's harder to envision a democracy compliant and charter compliant law that would limit disinformation about matters where there's serious and robust public policy and political dispute, like carbon pricing or the other issues you mentioned.
Mm-hmm. Okay. Any other thoughts from Anastasia-Maria or Lynne?
I was going to say it's about and Michael has said this already, but it's about discourse. It's about having conversations rather than being critical. It's dealing with people respectfully and getting across the getting across your side, which you could argue is the truth. But I think it's really about the discourse.
Mm-hmm. One of the challenges that is emerging here is the fact that a lot of these platforms and indeed the generative AI tools like ChatGPT, et cetera, are based in the United States. We have tried, as I mentioned earlier, with the Online News Act to restrict, at least not restrict so much, but try to have a working relationship between Canadian news media and those platforms. How much freedom do governments in Canada have to regulate misinformation when these platforms are located outside the country? Maybe I start with you, Michael.
Tough issue that's really kind of been in our faces for about the last decade. Most of the platforms are based in the US, some in China, some in some other countries. Sometimes people talk about the need to use competition law to break up the platforms. That's kind of complicated legal question, but very hard if the entities are outside of the jurisdiction. Any robust regulation, they have the option, and they sometimes threaten to do, to simply leave Canada. That was sort of the dynamic in Australia around a similar piece of legislation around the news bill, where social media platforms simply said they would leave the jurisdiction. And to be honest, it's a brave politician who wants to take on Elon Musk as they propose robust regulation of X or Twitter as it was. But it's something that we have to do. Probably suggests we need to act in concert with other like-minded democracies, and maybe we have a bit more power to do so together. But Canada is a valuable market for these platforms. Sometimes the negative impacts here are because the engineer in Silicon Valley in California changes the algorithm, and they're not thinking of the impact on the Saskatchewan provincial election when they change something about how advertising happens on the platform. So some of it can be solved simply by discussion. Some of it requires a heavier hand and commitment to dealing with the effects that it causes.
If I could extend from that, as individual organizations and institutions in our engagement with these platforms, a small debate going on in university departments such as mine is whether we should continue to participate and engage on platforms like Twitter and others where we don't find the discourse particularly helpful, but is leaving those platforms an appropriate response and not engage in those conversations. So if we're talking about trying to counter misinformation, we're talking about trying to educate the public, it's not an easy choice. And where would you argue is the appropriate place to be? Engaged in those platforms or dismissing them and deleting your account? Lynne or Anastasia-Maria?
I'll jump on that one because that's one I personally struggle with. I do have an formerly known as Twitter platform. I keep up there. I do post on that platform. I think it's important to listen to voices with opposing views to each other. We have to do that. And if we disengage from platforms because we find them uncomfortable or we disagree with the people, I think we're at a risk of becoming even more siloed and living in our own echo chambers. So I watch news media outlets that I find difficult. I read newspapers that I find challenging, but I think that we all have to continue to do that. We have to continue to engage in those difficult discussions because the alternative of just staying in our own bubbles is not going to get us out of this polarization that we're seeing now.
Mm-hmm. Mm-hmm. Good point. Anastasia-Maria, can I come back to the issue of regulated professions and the way they interact in, for example, social media platforms? If I'm remembering the Carolyn Strom case, one of the suggestions, I think, from her team to the regulatory body was that she write essentially guidelines for professionals in engaging on social media. I don't know if that ever happened with the various versions of her case as it went through the courts. But is this something that regulated professions should be engaging in, is trying to provide guidance and education to their constituencies around what's appropriate and good ways to engage in social media?
Yeah, I think it's helpful. I mean, the goal of almost all regulators is to protect the public. And so any sort of, proactive, I think was the term we were using earlier, any proactive type of education campaign or guidance to the profession on issues as they come up, I think is helpful. Most of the professions that, at least the ones that I interact with, generally have a set of standards of practice that can be used in multiple circumstances. They're just because they, didn't contemplate something happening doesn't mean that they can't be used for that situation. So, general ideas about professionalism, standards about professional communication with clients, with the public, that kind of thing, in emails or in person versus on social media, the general concepts, I think, and the principles, the basic principles still apply. But when issues come out that are new and are challenging to the profession, certainly I think it's helpful for regulators to let people know what the expectations are or how, or even to refer them to the previous guidance, say, these principles still apply. And I think it's important for regulators also to be live to the issues in their own profession, because they may not always be the same, right? Like health professionals are going to deal with different concerns than forestry or professional resources professions. And they may all be engaging with social media, but I imagine that sort of a lot of the pertinent issues may be different. And so it's also important for regulators to know and have information and evidence about the challenges facing their own particular profession, so that they can respond appropriately to them and make sure that they have their finger on the pulse.
Mm-hmm. Okay, thank you. And I've got one final question from the audience, and then we'll turn it over to the panel for closing remarks. Brett Dolter writes by starting with a citation to Yuval Harari's book, Nexus. where Harari talks about the point of social media platforms is to maximize user engagement. So rage posts get more clicks. And that the fact that we're the product when we engage in social media and our attention to those platforms is what drives the algorithms and the other mechanisms that keep us engaged. So maybe, Michael, if we can start with you, do you see a different model for regulating social media that gets away from this this primary business model, which is attention, and attention being driven by the most outlandish, ridiculous statement one can come up with to get attention?
Yeah, so in the election advertising context, it comes up a lot because a negative ad or communications that stir up very strong emotions will get more views, and so there's more incentive to spread that through the platform, which probably has undesirable effects for democracy as a whole. The platforms weren't designed with supporting, protecting, enhancing democracy and election integrity in mind. They're there to sell sneakers and to sell makeup and to sell all the other things that advertisers want to sell. So they have their own commercial interests, which they're absolutely entitled to have. But they're not going to switch that business model as long as it's profitable. So it's incumbent on governments to come up with legal solutions that try to protect democracy, protect the courts, protect public regulation of professionals on those platforms. So we're in the early stages of it. Is there a great model around the world that we can draw on? That's a harder one. We looked a lot to Australia with the news legislation. The online harms bill federally that didn't not all of it passed. That was modeled a lot on the UK legislation with some changes. So we're trying to learn from other jurisdictions, but it's a difficult job, but it's one that I think falls on governments across Canada.
All right. Well, I can't thank the panel enough. I'm going to move towards wrapping up here before our time disappears from us. But I'm going to leave you with one last question for each of you. If you could address the question, what one concrete step would you recommend that legal professions, whether that's lawyers, judges, or academics, what one concrete step would you recommend legal professionals take to help rebuild and protect public trust in our institutions in this context of a rising tide of misinformation? Lynne Vicars, can we start with you?
Certainly. Rebuilding trust requires more than any organizational leadership. It requires every one of us to see public engagement as part of our duty. Educating the public about legal processes and democratic values is going to strengthen trust, and it's going to shield against many of these risks that we've talked about today. So one concrete step that we can all take, and this is really a shameless plug, but it's to help engage in the public legal education by using the CBA's toolkit and resources by others. And I just had a meeting recently. I know the ABA, the American Bar Association, is also coming up with a toolkit on engaging with the public on why these things matter and talking about disinformation and misinformation. So I implore you all to join in the fight. And that's my pitch.
Excellent. Thank you, Lynne. Anastasia-Maria.
So in the context of sort of regulatory law and regulatory lawyers, which is where I operate, I think familiarizing yourself, like it's a pretty basic step, but familiarizing yourself with the test, the balancing test, knowing what the charter rights are, knowing what charter values are, familiarizing yourself with all of that. It can seem quite daunting, I think, to talk about the charter and understand the charter, but really getting into it and knowing that that way you'll be alive to issues, you'll be able to spot them as they come up, and then you can really make sure that you're engaging in that appropriate balancing between, protecting the public and protecting people's charter rights or the charter rights of professionals. It seems daunting, but I just encourage you to really get into it, because once you start learning about it, then it seems so much more intuitive to issue spot and make sure that you're really, you know, getting into that balancing and that discussion.
Great, thanks, Anastasia-Maria. Michael Powell, last word to you on this.
I think we have to rediscover something that we've forgotten a little bit, which is the importance of civics education, kind of all through the educational cycle. You know, I teach my law students about public law and the charter, but it's a small group in the larger scheme of things. A lot of disinformation, at least in the electoral context, is about basic features about how the system works. Things would function a lot better for Canadian democracy if those were things people already had the accurate information top of mind because they had learned it along the way. So civics education became unfashionable at some point. I know some jurisdictions do it better than others, but I think we need to rediscover why we had it in the first place.
Mm-hmm. Great, thank you, Michael. Well, Lynne, Anastasia-Maria, Michael, thank you all for your time today and for offering your perspectives on this timely and challenging topic. You've given us all a lot to think about as individual citizens and in our collective efforts to build a stronger Canada. I'm now pleased to turn things over to Jesse Bidens, CBA Saskatchewan Vice President, to close the event. Jesse.
Yes, thank you for that, Justin. First, I want to extend my gratitude to the Johnson-Shoyama Graduate School of Public Policy for their continued partnership, which began as an opportunity to celebrate Law Day and the signing of the Canadian Charter of Rights and Freedoms. That tradition continues today, fostering essential conversations on pressing issues like misinformation and its impact on trust in our public institutions. Today's discussion has shed light on the challenges misinformation presents, particularly in legal, regulatory, and electoral systems. I know AI and that is scary for a lot of us on this call that are lawyers, so I appreciate the insights shared. They've been very thought-provoking, and they underscore the urgent need for thoughtful approaches through law, policy, and best practices to combat misinformation's harmful effects. So as we move forward, let's carry today's conversation into our own circles, helping to strengthen trust and accountability in the institutions that shape our society. I'd also like to give a heartfelt thank you to our distinguished panelists, our organizers, and our sponsors for making this event possible. Your contributions are recognized and appreciated very much. If you found today's discussion insightful, I encourage you to keep an eye on the calendar of events for the JSGS and the CBA Sask, where upcoming events are regularly posted. And before we conclude, I just want to thank you once again, recognize our speakers for their time and their valuable insights. So thank you very much for joining us today. And I wish everyone a wonderful afternoon and a beautiful looking weekend. Hopefully you can all get out and enjoy that. So thank you.
Thanks very much.
Thanks, everyone. Have a good one.